My name is Richard Samp. That's S-A-M as in Mary, P as in Peter. I am Senior Litigation Counsel at the New Civil Liberties Alliance, and I've been representing Michael Cargill, the plaintiff in this particular lawsuit. The federal government has decided to step in and try to change the criminal laws by itself. That's a federal administrative agency, the ATF, has said that bump stocks are machine guns and are illegal, even though the law doesn't say that, and even though for many years ATF, during both the Bush and Obama administrations, said that bump stocks are not machine guns. This change in position is something that ought to originate only from Congress. It is Congress that writes the criminal laws, and that's what we asked the Supreme Court today to hold. We thought we got a fair hearing, and we are very hopeful that the court will rule in the next several months that it is up to Congress to write the criminal laws, not the ATF. Thank you.
Hi, I'm Michael Cargill, that's Michaelcargill, owner of Central Texas Gun Works, all separate words. What we heard today here is that there's a clear thing that we need maybe Congress to take a look into, and that's changing the definition of what a machine gun is, because clearly bump stocks do not fit into that definition. We go back to President Obama, who actually, under that administration, said that bump stocks are actually something that we all can own. That administration was very strict in being the administration to actually come down on the Second Amendment community when it pertains to firearms. So being that this is something that was approved on the Obama administration, carried over to the Bush administration, I think we should definitely take a look and see what's the differences and why the ATF changed their mind all of a sudden. Because on the one hand, bump stocks are legal under several administrations, and then on the other hand, someone else steps in, they become illegal. So we'll see what the United States Supreme Court says and how they weigh in on this case. And I think it will be something that we're going to look at for decades to come. This is a very important case, I feel, that will be used as case law.
I'm Mark Chenoweth, M-A-R-K-C-H-E-N-O-W-E-T-H, President of the New Civil Liberties Alliance. We're proud to represent Michael Cargill in front of the Supreme Court today on what is a very important issue of administrative power. We've been talking about the Cargill case as maybe being the hidden administrative law case of this term at the United States Supreme Court. Obviously, there are a lot of other important administrative law cases pending, including the relentless case that NCLA argued last month, and the Murphy v. Missouri case that we'll be arguing next month at the Supreme Court. But what makes the Cargill case so important is that we had a federal administrative agency, ATF, create new criminal liability. And that's not something that any federal agency can do. Only Congress over here is allowed to write criminal laws, not federal agencies. And if we live in a world where federal agencies can create criminal liability, then we all have to fear for our liberty. I want to thank Michael Cargill for standing up and being willing to take this case, and we've been representing him since 2019. It's been a long road to get to the Supreme Court, but we were very happy with the reception that we had inside from the justices today. We certainly think that they were interested in the textual arguments as to why the statute that bans machine guns just doesn't apply to bump stocks. And when you think about it, one of the justices said, well, we have to look at common sense. I think it was Justice Kavanaugh. Well, here's the common sense argument. A bump stock changes the stock of a weapon. It doesn't change the trigger. It changes the stock. And there's nothing about a semi-automatic weapon equipped with a bump stock versus a semi-automatic weapon not equipped with a bump stock that changes the way that the trigger mechanism functions. And we define the machine gun, the statute defines machine guns for purposes of banning them based on the function of the trigger. The function of the trigger just doesn't change in Mr. Cargill's bump stock, and that's why it's not a machine gun. And if the court were to decide that it is a machine gun, then you'd have to worry about lots of other semi-automatic weapons as well, because as I say, there's just nothing about this weapon and the trigger function of it that's any different from other semi-automatic weapons. Thank you very much.
Hi, Sheng, S-H-E-N-G-L-I, Litigation Counsel at the New Civil Liberties Alliance. Back in 2017, Congress was debating whether to change the statutory definition of machine guns to encompass bump stocks. And before Congress had a chance to wrap up the debate and make a decision, ATF came in, swooped in, and made the decision for Congress by rewriting the statute, rewriting the law. That's not how it's supposed to work under our Constitution. Only Congress gets to write the laws. And today, the Supreme Court, we hope, will rectify that mistake and actually echo what then Senator Dianne Feinstein said when ATF did this. She said the ATF's interpretation was unlawful because the existing definition of machine gun didn't cover bump stocks, and that's all we're saying today.